Hey guys, I am Devi Sanal and welcome back to Devi's Law Capsule. This video is regarding writs and different types of writs. First of all, let's see what actually writ means. Writ means it is an instrument or order of the court, that is Supreme Court or High Court, by which the court directs an individual, official or public authority to do an act or abstain from doing an act. Next is that there are 5 different types of writs, that is Habeas Corpus, Mandamus, Prohibition, Certiorari and Covarendo, and these writs are known as prerogative writs. And Indian Constitution has adopted the concept of prerogative writs from English common law. The power to impose all these writs vests with the Supreme Court and High Court. That is, Supreme Court can issue writs under Article 32 and High Court can issue writs under Article 226. So the main difference between Supreme Court and High Court with regard to the issuance of writs is that Supreme Court can issue writs only for the enforcement of fundamental rights. So because of this feature, Supreme Court is known as the protector and guarantor of fundamental rights. Even B.R. Ambedkar has said Article 32 as the heart and soul of the Constitution. Next is about High Court. That is, High Court can issue writs not only for the enforcement of fundamental rights but also for the ordinary legal rights. So this is the main difference between Supreme Court and High Court with regard to the issuance of writ. Now let's see the literal meaning of all these writs. Okay. First is Habeas Corpus. Habeas Corpus literally means to have the body or to produce the body before the court. Second is Mandamus. Mandamus literally means we command. Third is Prohibition. Prohibition means to stop or to forbid. Fourth is Certiorari. Certiorari means to be certified or to be informed. And fifth is Covarendo. Covarendo means on what authority one is holding the public office. Now let's see these writs in detail. Habeas Corpus literally means to have the body or to produce the body before the court, and this writ is issued to produce a person who has been detained whether in prison or in private custody before the court and to release him if such detentions are found illegal. The main object of Habeas Corpus is to provide a quick and immediate remedy to the person who has been detained illegally. Next is that who can apply for writ of Habeas Corpus. That is, if a person is detained unlawfully, he or his friends or relatives can file an application for writ of Habeas Corpus under Article 32 or 226. Now let's see against whom this writ can be issued. That is, this writ can be issued against public authorities and private individuals. Moving on to the conditions under which writ of Habeas Corpus cannot be issued. First point is if the detention is lawful. Second point is contempt of court or legislation. That is, if the proceedings before the court is for any contempt of legislation or court. Third one is competent court. That is, if the detention is done by a competent court. So, under all these circumstances, writ of Habeas Corpus cannot be issued. Now let's see some of the important cases that comes under Habeas Corpus. In ADM Jabalpur versus Shivakanta Shukla in the year 1976, the court held that writ of Habeas Corpus cannot be suspended even during the period of emergency. In Sunil Batra versus Delhi Administration in the year 1970, in this case, the petitioner addressed a letter to the court that the jail authorities were assaulting another prisoner, and the court treated this letter as a petition for Habeas Corpus. So in short, we can say that Habeas Corpus is a powerful weapon that is available to a common man who has been detained wrongfully by the person or state. Moving on to Writ of Mandamus. Mandamus literally means we command. This writ is popularly known as Writ of Justice. Okay. Writ of Mandamus is a command that is issued by the Supreme Court or High Court when any inferior courts or government officials or any public authority has to do a public duty but they fails to do so. So in such situations, a Writ of Mandamus is issued. Hence, we can say that mandamus is an important writ to check arbitrariness of administrative action. Next is that who can file an application for writ of mandamus. That is, if a person's legal right has been violated, in such situation he can approach Supreme Court or High Court for writ of mandamus. Now let's see against whom writ of mandamus can be issued. That is, it can be issued against inferior courts, government officials or public authorities. In Bharadakanda versus State of West Bengal, the court held that writ of mandamus cannot be issued against private individuals or private organizations because they are not entrusted with public duty. In Ranjan Dwivedi versus Union of India in the year 1983, the court held that the writ of mandamus cannot be issued when the government is no duty under law. So the main purpose of writ of mandamus is to ensure that the powers and duties are not misused by the administrators and executives and they are fulfilled duly. Moving on to writ of prohibition. The term prohibition literally means to forbid or to stop. This writ is also known as stay order. Writ of prohibition is issued primarily to prevent an inferior courts or tribunals from exceeding its jurisdiction or acting contrary to the principle of natural justice. The underlying principle of writ of prohibition is prevention is better than cure. In East India Commercial Company versus Collector of Customs in the year 1962, the court held that writ of prohibition can be issued in both cases where there is an excess of jurisdiction or absence of jurisdiction. Next is that who can apply for writ of prohibition. That is, if a person's legal right is violated, in such situation he can approach Supreme Court or High Court for writ of prohibition. Now let's see against whom writ of prohibition can be issued. That is, it can be issued against judicial and quasi-judicial authorities. Now let's see some of the conditions under which writ of prohibition is issued. That is, writ of prohibition is issued against judicial and quasi-judicial bodies and these bodies has exceeded their jurisdiction or acted contrary to the principle of natural justice and the whole proceedings must be pending before the inferior courts. So in such situation, writ of prohibition is issued. Moving on to writ of Certiorari. The term Certiorari literally means to be certified or to be informed. Writ of Certiorari is issued by the Supreme Court or High Court for squashing the orders that has already passed by the inferior courts, tribunals or quasi-judicial authorities. So this writ acts as a corrective remedy whereby the Supreme Court and High Court investigates the legality of the orders that is passed by the inferior courts, tribunals and quasi-judicial authorities. The main object of writ of Certiorari is to keep inferior courts, tribunals and quasi-judicial authorities within their limits of jurisdiction. Now let's see some of the conditions under which writ of Certiorari can be issued. First is excess of jurisdiction. Second is error of law apparent on the face of the record. And third is that where there is a violation of natural justice principle. So under all these three conditions, writ of Certiorari can be issued. In Gullapalli Nageshwara Rao versus APSRTC and in AK Kripak versus Union of India. In both these cases, the lower court's judgments were held illegal and squashed. In Basappa versus Nagappa, the court held that the superior court can squash the order of the inferior court. So now let's see the difference between writ of prohibition and certiorari. First point is that writ of prohibition is issued before the proceedings are completed, whereas writ of certiorari is issued after the decision made by the inferior courts, tribunals or quasi-judicial authorities. And the second point is that the underlying principle of writ of prohibition is prevention rather than cure. And in the case of writ of certiorari, it is used as cure by squashing the decision already made. In Madan Gopal versus Union of India, in this case, the court held that writ of prohibition is issued to prevent the administrative action or decision in process. And the writ of certiorari is issued to squash the decision already made. Moving on to writ of Covarendo. Covarendo literally means on what authority one is holding a public office. Covarendo is a judicial order asking a person who occupies a public office to show by what authority he holds the office. Here the office must be a public office, and this point was raised in University of Madras versus Govinda Rao. Second point is that the office must be substantive in nature, that is, it must be permanent in nature. And third point is that the person who is holding the office should have actual possession. And fourth point is that the office must be held contrary to law. So the main object of writ of Covarendo is to prevent a person to hold a public office which he is not entitled to hold. So these are some of the important points relating to writs and different types of writs. With this, we came to the end of this topic and hope you guys benefit from it. And if you find this video useful, please do like, share, subscribe and also press the bell icon for more updates. Thank you.